your preparation in Massachusetts different from, or was it the same as in Vermont? And why did you file in Massachusetts when you did?
Gary, you were there. Would you like to answer that? Well, I would love Gary to weigh in on this as well. I will say this, Beth is quite right. Absolutely, I've learned plenty from that experience in Vermont. So, for example, I think we had all been thinking the court was going to do its thing, and the legislature was sewn up, and we didn't have to worry about a constitutional amendment. But then there we were in the legislature, and I simply didn't know where this was all going to go in Massachusetts. But one of the things that we did very deliberately, our plaintiffs in the Vermont case were all from the Burlington area. They're all fabulous people, and we were very fortunate to have them. But we were very determined here to have people from different parts of the state and from different walks of life, just to show, as we did in Vermont, but how human an issue it is and how local an issue it is. And then there's a fact I want to just put out there that I'm not sure everybody knows, but maybe everybody does. You know, after Vermont and the whole civil union thing, like I lived in Massachusetts at the time, and people come up to me in the grocery store and they'd say, literally, hey, what about Vermont? Why can't we do that here? What about Vermont? Hey, why can't we do that here? I was like, okay, I know. We can maybe do that here, okay? But it was a different environment. I mean, we were under the reign of Tom Farron in the legislature. It wasn't very easy to get anything to move at all. You know, courts changed and so on. As you know, on the court at the time that Goodridge was decided, 6 of the 7 members were appointed by Republicans. You know, it's a different political landscape. But the thing that I wanted to mention, and I'm not sure that everyone is aware of, is that it is true after Vermont we were absolutely planning on moving forward in Massachusetts, but something that I think really hastened our timing and made sure that we got that case prepared and filed is that we almost had a constitutional amendment vote here that would have come to fruition in 2004. And knowing how many states, I mean, by the time we filed the Goodridge case in April 2001, there were 37 states that already had statutes or amendments banning marriage for same-sex couples. We'd want marriage nowhere in the country, and still there were all these bans out there. So we believed that we needed to have this fight and either win this case so people knew what they were voting on, or lose it, in which case people would say, maybe that was wrong and unfair, and we definitely don't need to pass this amendment. So it turned out, of course, that through a chain of events that Tom Birmingham gavelled that constitutional convention to a conclusion in 2002, and we didn't have to face that amendment, but we had to face that whole prospect in future years. But I just want to say that that definitely was a factor focusing us. But Massachusetts, like Vermont, you know, is a state that's committed to equality. It's a state where no branch of government, gay and lesbian families were not a stranger to any branch of government, and all those things matter. You know, this is a state where Barney Frank is from, and Gary Studs, and you know, just all kinds of cultural reasons why gay people are a part of the fabric of the community. So I remember being very happy when we filed and seeing some of the news reports where, you know, reporters would say things like, 5 years ago I would have thought this was a big deal, but now, oh, come on. Now, of course, the oh, come on, we had quite a fight here, and I realized that. But again, it was just received in such a different way. So Massachusetts was still, I think, ahead of many people's comfort level, but it was the right, for Massachusetts, the right case to bring at that time. And of course, you know, in preparing one of these cases, what do you think? You know, we look at everything. You know, look at every single constitutional ruling that bears on equal protection and due process before you go in. You know, really try to get a feel for the true history and the narratives about the history of the state. You know, being John Adams, being from Massachusetts, being right from the area, and his whole role in not only writing the Massachusetts Constitution, but how the Massachusetts Constitution influenced the federal Constitution. John Adams, I don't know, people, I guess his reputation is that he was a bit verbose. So there are several equality provisions in the Massachusetts Constitution. You know, we could rely on all of them. So anyway, it's the kind of preparation that you would expect. And really, as always, we remain so grateful to the people who were the plaintiffs in that case, who put themselves out, and you know, that vulnerability really makes all the difference.
You know, I mean, I know that the questions about what Mary did differently, I wasn't there, but from a distance, reading your complaint, one of the other things I think you learned from Vermont is when we framed the message in Vermont, we focused excessively on the tangible legal benefits that come with civil marriage. You know, the hospital visitation or the inheritance or the this or that, and we neglected to really talk about what marriage means in the world that we live in, what it means writ large. And that came back to bite us in a big way in the Baker decision. In fact, I was on a panel with Justice Morse, who was on the Baker panel, was one of the co-authors of that opinion, and he acknowledged, it was just a few months ago, that they just didn't realize. At the time, it didn't really occur to them how insulting a separate status might be and how marriage in itself had a meaning. And that's partly our fault, because it's our job to teach them that and tell them that. And certainly one of my biggest regrets in terms of mistakes, forgive us, but it's something we missed in briefing the Baker case, and it's something you all hit so hard and so well in Goodridge, and I think that's another example of learning our lessons.
She's so nice, and I don't feel that way. Here's another counter interpretation of it all. I think that you could certainly read everything we wrote and believe that we were asking for marriage, and that I can think of incredible, working with Beth and Susan on this. It was the time of fax machines. Okay, so faxes would come in for 2 hours. It was like briefing this thing was unbelievable together, and 3-hour conference calls, and then your 2-hour fax, and then you do it again the next day. I think we were incredibly clear about marriage and talked a lot about the fundamental right to marry and how it defines your person and the importance of that choice. And they glossed over it for whatever reasons. So it is true. We definitely did not focus on benefits in the same way, but I really believe still that the court could have gone a different way. I can't help but think personally, this is my supposition only, that when Beth did the brilliant job arguing that case in Vermont in November 1998, you have to remember it was just 2 weeks after Hawaii amended its constitution, 2 weeks after Alaska amended its constitution. And if I were a court thinking about this, I might say, isn't there another way? Marriage seems to be such a tough issue here. So I do not know that. I do not know that, but I can't help but think that may have influenced them in some way to say, you're seeking the benefits and not marriage. I believe we were incredibly clear about seeking marriage, but also trying to educate the court about all the things that come along with marriage as well. Maybe that's unfair. You can.
No, that's fair. I didn't mean to insult us so much as compliment you.